Illinois' gun and magazine ban still in effect after Friday's ruling by the Illinois Supreme Court, a split decision 4-3, with the two justices that got $1 million each from Governor J.B. Pritzker when they were running for office being split. Justice Elizabeth Rochford leading the majority opinion, and you had the dissent, a couple of the Republican judges, but also Mary O'Brien, the other justice that got $1 million from Governor J.B. Pritzker. What does that mean for any kind of challenge moving forward on a Caperton-Massey challenge to the U.S. Supreme Court? We'll delve a little bit into that. We'll also delve into the cases that Attorney Thomas DeVore still has, which, correcting the record, on Friday, I was under the assumption that the temporary restraining orders that DeVore received in his cases across several counties that are now consolidated in Effingham County. He's got thousands of temporary restraining orders. Those are still in effect until a court dissolves those. So I'll share with you some of the conversation I had with Thomas DeVore as well. But a lot to get to with this. And of course, this wasn't the only thing that happened over the weekend. On Saturday, Governor J.B. Pritzker signed another gun regulation bill. This time, you have the firearms industry vulnerable to lawsuits in a measure that the governor signed on Saturday. So that's some of what we're going to get to today. But of course, let's focus on the Illinois Supreme Court and their ruling on Friday, which does not impact the federal case. All right. So that's still pending. We're waiting for the Seventh Circuit Court of Appeals in the federal court system to release their ruling on the challenge of the gun and magazine ban here in the state of Illinois. So let's go ahead and pull up the ruling here and just highlight a few of the various things that we have spelled out in the Illinois Supreme Court ruling. And of course, we reviewed this just briefly on Friday, right as it came out. And I appreciate everybody always checking out the updates and the page and on YouTube or on Twitter and Facebook. By the way, welcome in Springfield's Morning News. I'm Greg Bishop on 92.7 WMAY. Follow me anywhere. Just search Bishop on Air. Let's go ahead and check this out. In the Illinois Supreme Court, you've got Dan Caulkins v. J.B. Pritzker in his official capacity, and Elizabeth Rochford delivering that judgment with three other justices on board, but you had three justices dissenting. And it talked about the Protect Illinois Communities Act and how we got to this point. And it highlights some of the the arguments that were made. And just that first paragraph, I think, really kind of spells it out. It talks about how the idea that they were arguing ultimately leading to, the issue of special legislation and to the issue of the equal protection. But they also say that they expressed no opinion on the potential viability of the plaintiff's waived claim concerning the Second Amendment. So, again, the Illinois Supreme Court ruling doesn't deal with the Second Amendment issues. It only dealt with special legislation and with the issue of equal protection, which means, equal protection under the law, you are to be equally protected as a class of individual and having your rights secured as somebody else. You can't craft legislation to say this person over here, because of their status, has more rights than this person over here that doesn't have that same status. So here we are. Let's go through some of this other, a lot of background. It's a 34-page ruling. But I do want to get to paragraph 40, which is on page 9 of this. And this is from the majority opinion. And if you scroll down and check it out, it says, second plaintiff's summary judgment motion invoked the Second Amendment only to demonstrate that they were similarly situated to the exempted classes. What are those exempted classes? Police, retired police, others in the security sector like prison wardens. They say that they motioned to invoke the Second Amendment only to demonstrate that they were similarly situated to the exempted classes for equal protection purposes. Acknowledging the difference between the Equal Protection Clause and the Second Amendment, plaintiffs asserted the questions pertaining to is not whether a weapon classification survives constitutional challenge. Rather, the question presented is whether citizens qualified to acquire and possess firearms and firearm ammunition can be treated differently in the application of the weapon classification. So it gives you a little bit of an understanding of at least the majority opinion and what they were looking at from the arguments. But then we go further into page 15, paragraph 62, where you've got the majority opinion spelling this out. Although the legislature did not state an express goal of the act, the statutory scheme plainly implements firearm restrictions in furtherance of public health, safety, and welfare, with exemptions for those who have undertaken specialized training as part of their employment in law enforcement, the military, or who have a reliance interest in retaining possession of items legally acquired before such acquisition was prohibited, and who adhere to new restrictions on possession and transfer. That's the grandfathering. And the act attempts to balance public safety against expertise of the trained professionals and the exception interests of the grandfathered individuals. So you have a balancing argument here that's being proposed in the order of the Illinois Supreme Court and the majority. So that's just a little sampling of the majority opinion. Now, the dissenting opinion, you had Justice Holder White, Justice Overstreet. They dissented. In their dissenting opinion, we'll just go to this really quick. Holder White, she says that the great nation was founded on the premise that the right of law-abiding citizens to bear arms is essential to what it means to be a free people. The right of law-abiding citizens to possess firearms and to arm themselves to protect their families, their homes, and themselves must not be infringed. There's also some arguments here about the 3 readings rule and whether or not that was followed. We'll touch on that a little bit as well. But you can read that for yourself. And that's the idea that you've got to have these laws before they become laws, these bills. They have to be read 3 times, right? The 3 readings rule. It wasn't necessarily something brought up explicitly by State Representative Dan Caulkins, but you still had the dissenting justices highlight this. But what's interesting, too, is you get to the dissent from Mary O'Brien. And she is one of the 2 justices that got $1 million to their campaign coffers from Governor J.B. Pritzker. And she had her own separate dissent, saying, "I respectfully dissent because I do not find that the classifications at issue in this legislation further its claimed purpose, and it is thus violative of the special legislation and provisions of our Constitution." So she goes through and highlights her arguments, essentially saying that the majority opinion got it wrong. She says, "In dissenting, I do not pass judgment on the intent of the legislation. Rather, I only consider whether it meets constitutional requirements under the equal protection and special legislation provisions of our Illinois Constitution. When we limit people's rights, even the rights we might not like, we have to do so in a way that honors the Constitution." So because the majority fails to undertake this appropriate analysis, she says finally, and finds the plaintiffs are not similarly situated, I respectfully dissent. I would find the legislation violates the constitutional prohibition against special legislation. And O'Brien actually, when she was campaigning, she talked about the importance of equal protection under the law. So it seems that she's carried that over into this particular dissent as part of the ruling that was released by the Illinois Supreme Court on Friday. So stay tuned. We'll hear what State Representative Dan Caulkins had to say. We'll also delve a bit into the Caperton v. Massey challenge that's possible, depending on if Caulkins wants to pursue that and take it to the U.S. Supreme Court to show that there was a conflict of interest or some kind of bias. And if that's the case, you could see this 4-3 decision turn into a 3-3 decision, and then the lower court ruling that the law is unconstitutional would stand. Is that a long shot? Well, we'll see what happens there. But of course, doing a little bit of internet sleuthing, and you're able to see where people can easily point to some photographic evidence that there's a little bit of smoke there when it comes to the perception of conflict. So stay tuned. A lot more to get to here with Springfield's Morning News. I'm Greg Bishop on 92.7 WMAY, Springfield's News and Talk. So So what's next in the challenge to Illinois' gun and magazine ban? Well, of course, you've still got the federal case, the Seventh Circuit Court of Appeals, hearing arguments around the Second Amendment, and that is still pending. When they're going to release that, who knows? But of course, we'll be watching that closely. In the meantime, Illinois' ban on semi-automatic firearms and magazines over certain capacities remains in place after the Illinois Supreme Court on Friday issued their ruling and the majority opinion, essentially saying that, no, it's okay. You can say, law enforcement and retired law enforcement can have semi-automatic weapons, and those who had them before January 10th can have them, but anybody else cannot. So that's at least the gist of the what they upheld on Friday. So what's Dan Caulkins' reaction? He's, of course, the Republican state's representative out of Decatur who brought this case. That is separate from Tom DeVore's case, which I talked with Tom on Friday, and I'll share some of what he had to say coming up, so definitely stay tuned to that. But here's Dan Caulkins reacting to the Illinois Supreme Court's ruling on Friday.
I'm a FOID card holder. Why am I treated differently from another FOID card holder? Well, because that FOID card holder happens to be in law enforcement. Why is that any different than me? 22 years in the military. I think I have earned the same consideration as anyone else or any FOID card holder that goes through the training, the proper training to get certified.
So he also, was reacting to what Governor J.B. Pritzker had to say, because Pritzker put out a statement after the ruling saying that this makes Illinois safer and takes weapons of war off the streets, the governor's words. And Caulkins reacting to that, saying, no, indeed, this doesn't make Illinois safer.
Just the opposite. It disarms honest FOID card citizens. It takes away common guns that they use for self-protection or to protect their families.
And Caulkins also talked about how crime in Chicago since January 10th has not gone away. It's been very real and seeming to be a steady increase. But what's next here? Can Caulkins take this anywhere else? Is the Illinois Supreme Court the last that his case can be heard in any kind of judicial setting? Here's State Representative Caulkins.
Well, the Illinois Supreme Court is the final arbiter of the law in Illinois, and that's what we were challenging. There are another avenue, of course, that on whether we've got an unbiased hearing or not. I don't know. That's up to my attorney, and we'll discuss that next week.
Well, and I asked him specifically about this Caperton challenge, which is a U.S. Supreme Court case dealing with judges in different states that had a hearing and a ruling on a case where one of the defendants in the case was a contributor to a judge, and it raised questions of conflict of interest, and that's Caperton v. Massey. You can look that up and do some research there. But, of course, Caulkins, in the trajectory of his case, had his attorney file a challenge asking for two of the justices to recuse themselves, of Elizabeth Rochford and Mary O'Brien. Those two justices refused to recuse themselves. So is it possible that you could have this question of whether they got a fair hearing advanced to, say, the U.S. Supreme Court to have them determine whether or not there was indeed a fair hearing? And again, Caulkins says that they can't make that decision quite yet.
I don't know the answer to that. It's going to be up to our attorneys on how they want to proceed and what actually we can afford to do.
And obviously, costs and litigation is very much something that is expensive. There's no question. But to the issue of Caperton v. Massey, if you search Facebook for Rochford Moms Demand Action, you will see a fair amount of posts here that show Elizabeth Rochford taking part in Moms Demand Action events and even being pictured with activists even after being sworn in. And that begs the question as to the perceived conflict of interest. Now, this is just one post, right? I mean, you can search Facebook for Rochford Moms Demand Action, and you'll see post after post after post of Rochford with these gun control activist groups, and highlighting how she's there at their meetings, and that's after taking office. But you've also got even before taking office, Judge Elizabeth Rochford right here. I was invited to speak with Moms Demand Action about how the judiciary interacts with gun safety laws and gun violence prevention. There's even one here where she said that she attended a fundraiser. And you can find those for yourself as well. Again, Rochford with House Speaker Emanuel Chris Welch, who gave 6 figures to Elizabeth Rochford. Rochford with gun control activists who is helping move forward with some of these gun control laws. So obviously you can search this and find all kinds of instances of Elizabeth Rochford essentially hip to hip with a lot of these gun control advocacy groups, which, again, the Caperton v. Massey challenge, if it does go forward, it could raise this question even more. But we've heard Governor J.B. Pritzker downplay these concerns, saying there's nothing to it. It's interesting to hear that, especially when you've got Democrats in Washington, D.C. all up in arms about U.S. Supreme Court Justice Clarence Thomas and the reporting that you're hearing about perceived conflicts of interest there. So I don't think we're done hearing about Caulkins' case. But what about Tom DeVore's case? Stay with us, all right? It is Springfield's Morning News on WMAY.